Hmm.
It's a regular checking matter. So with Thailand Milot IA for subscription of the defendant.
3839. Yes, what is it?
The Milot for requisition for the
What?
IA for subscription of the defendant. Two defendant died. 5 years that
You want to
bring the record of the for requisition. Item number 8.
Hmm?
Item number 8. I thought that somewhere lost the people. I have to
which one? Item?
Item 8.
Yes, what do you want?
After
At the request of the Learned Council for the appellant, the matter stands adjourned to be listed after item 8, no?
I have filed a civil division petition today. I'm praying for the testing of this matter on Monday. Tell you the document and item number 11. But the admin council let me with passport session due to some medical emergency went to test new upload. Meta may be
Item number 11, we listed up the
but we just of the medical agency of family member you went to receive.
we'll have it on 3rd of June.
No, but
Yes. I won't be there. 3rd of there is a chance of it. The request of the Learned Council appearing on behalf of the appellant matter stands adjourned to be listed on 3rd of Well, the matter is come up for order. Let's see what happens when the matter is taken. Don't mention a 2005 arrest. What will people think? If it is you have not filed within time, I will abate it. Don't worry. Matter ends. Yes, what is this?
may I please your Lordship, the impugn order date 6/4/24 passed by the Learned Court of Fifth Petition number 1, Kampur Metro, Guwahati. Case number 1052 of the 23, arising out of that.
Page. Page.
Lord, impugn order, Lordship will find it page 376. Start from 376 to 401.
Yes, what is this order for?
Order is demolish the wall. Operative portion, my lord, from page para 40, page 400.
Yes.
So what happened, my lord? An injunction order, ad interim injunction order was passed. And that order, Lordship will find at page 147 to 159.
What is that?
What seven? My lord, I am at page number 157. Only my lord, 157.
Who is the plaintiff?
He is appearing. Lordship, my counsel is on the way. It's stuck up somewhere. My
Don't
counsel.
worry. You are there. Take your seat. Don't worry.
Lord.
Yes.
My lord, at page number 157.
Hmm.
But the learned court page, court to appoint one coming. So that lordship will find it page number 157. On the date of passing the ad interim injunction.
Yes. What
This
is
is
the
the order
order?
dated 16/23. In the result, the circle officer,
Page. Page.
page 157.
Yes. Yes.
in the mid portion first para. Therefore, considering the nature of the dispute, this court thinks it deemed fit and proper to appoint an Amin commission to identify the land of the petitioner and the OP and to submit report as to whether there is any encroachment made by the OPs over the land of the petitioner, and after arrival of the report, the court will decide the injunction application in accordance with law. In the result, the circle officer
The injunction application was an injunction for restraining,
Yes.
prohibitory injunction.
Yes, prohibit.
Then-
Is hereby appointed as Amin commissioner to ascertain the following facts. So these are the 4 facts upon which learned court needs some sort of clarification. So now, proceed. Report is furnished, and about the fate of the report, that is reflected in the impugn order also. My lord will find para 32 of the impugn order at page number 395.
Yeah.
Para 32. In addition, the court did not consider Amin Commissioner's report for lacking clarification on the points raised by the petitioner. No cross-examination or hearing regarding the acceptance or rejection of the report occurred. Furthermore, the opposing parties' counsel argued that the petitioner failed to include the building in the schedule within the plate and that the prayer for mandatory injunction should be discussed. So this is the fate of the report.
Then-
So there is no material on record to show that we have encroached the land of the plaintiff. Thereafter, what happened after passing this injunction order, my lord, after the Puja vacation, now the plaintiff come up with 3 petitions. One is injunction violation. Second one is to give a direction to the
Where is the injunction order?
injunction order, my lord, 6/10/2023 order, my lord. That lordship will find from page number, the long order, annexure 3 147.
Therefore, considering the nature, but where is the order of injunction?
Order of injunction, my lord, page 159.
On 59.
Not my lord. 158.
58 is-
Further, considering the nature of dispute, this court finds that there is an attempt of construction made over the suit property by both the parties, and if any permanent construction or structure is completed till the circle officer dispute revenue circle submits report, then the very purpose of filing the suit may become infructuous, and there may be some multiplicity of proceedings under the aforesaid circumstances. This court finds that the subject matter of the suit requires to be protected from any aggressor act of either parties, so that the subject matter remain intact till the court decides the injunction application in accordance with law. The subtle position of law says that the subject matter of the suit only can be protected by granting an order of status quo, and justice should not be defeated if the parties are directed to maintain the status quo till the circle officer dispute revenue circle submits its report before the court, and
But
till
it
the
was passed on 610,
610,
not to raise any construction.
not to raise any concern.
Then did you raise any construction?
No, my, because my lord, kindly now coming to the plain. In the plain, my lord, plaintiff has relied upon one FIR lodged by the wife of the plaintiff. And in the written objection,
Now, what has happened to the order 39 rule 2A?
against that, we have filed our written objection. So now that will go for evidence.
What is the allegation in order 39 rule 2A?
In order 39 rule 2A, my lord, and in the present mandatory injunction application also, allegation is same. Whatever fact has been narrated in the plain, all are stated. Thereafter, it is added that after passing the injunction order dated 610, we have raised
Did
one.
the circle officer give a report that there is a, that plaintiff's ingress and egress to his land has been blocked?
No, to that effect, no, sir. No. That's why Honorable Learned Trial Court law also rejected the Amin Commission, as reflected in para 32 of the impugn order. Therefore, what happened in the plain matter? The plaintiff has relied on FIR, which is lodged by the wife of the plaintiff, which says that the right of way is blocked. That lordship will find document number 29.
This mandatory injunction is given under what rule?
application was filed under section 29 of the specific thing,
Not 29, 39.
not mine. In fact, there is no mandatory injunction prayer in the plaint also.
Not necessary, but if something happens, they can do. But the application is filed under section 39.
39.
Now, power under 39 is given, or any interim power is being exercised, is given under what rule? 37 specific relief.
Yes, my lord.
Yes.
Chapter 7, it is about injunctions generated.
Kindly read 37.
37 temporary injunction are such as to continue until a specific time or until the further order of the court, and they may be granted at any stage of a suit and are regulated by the Code of Civil Procedure 197. A partial injunction can only be granted by the decree made at the hearing, and upon merits of the suit, the defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the state.
So, the application may have been done under 39,
39 mandatory.
but when the suit is pending, the power which is being exercised is under Order 39, Rule 1 and 2.
Yes.
37.
But they have not invoked that.
Whether they do or not, the question is, the court is exercising a power. The court is exercising in terms with the Code of Civil Procedure. If it is done under 39, read with Order 39, 1 and 2, because with Order 39, Rule and 1 and 2, you can very well file an application for mandatory injunction. Then, under such circumstances, whether the order is not appealable.
My lord, this question also comes to my mind while filing the present application.
Mm.
But in my understanding, what I feel that there is a separate application for Order 39 Rule 1. And in that application,
That is for prohibitory.
Yes.
Kindly see, that is a prohibitory injunction sought for.
Yes, ma'am.
I'm not on that.
Yes.
Is there any bar to file another application? No, there's no bar.
No bar.
So therefore, they have filed that application.
Yes.
Maybe they have mentioned only section 39
Yes.
as mandatory injunction.
Yes.
But mandatory injunction, if it is given during the pendency of the suit, it will be an exercise of power in view of section 37 under the provisions of Order 39, Rule 1 and or even under 151. That's a different aspect of the matter. But the question arises, wouldn't it be a appealable order?
My lord, what I understand that as the order is passed in an application filed under section 39 of the
Understood. You see,
so I feel that
Mr.
it is
Counsel,
a
kindly-
proceedings that
kindly
is written in
appreciate.
1-1.
Kindly appreciate one thing.
Yes, sir.
Section 39 is a power to grant an injunction, mandatory. Section 34 is a power to grant a declaration. Section 41 is a power or is a restraint upon the court to grant an injunction. So are the substantive powers. This is the power which is being exercised by the court. But how? In view of section 37, the power during the pendency of the suit is being exercised under the provisions of Order 30, the code. And if it is done in the terms with the code, then in that sense, it has to be a power exercised under Order 39, Rule 1 and 2. There's no quarrel with that proposition. Whether they put it or not under Order 39, Rule 1 and 2, the power which is being exercised is under that provision. Or maybe under 151, that's a different aspect of the matter. If it is 151, definitely, you can file a revision against that or 227 against that. You can come out. But against an order, because it can't come under 115, you have to come under 227 because that application, if allowed, would not dispose of the suit. So it won't come under 115, but it will come under 227. Now the question therefore arises, if that order is appealable, can this court take up this matter? And what is the value of the suit?
Hello, my lord. Forty lakhs.
So here it can come. It can come out here, but it will be it has to be an FAO.
Then, my lord, I may be allowed to withdraw and to file a file
I think
under
better.
order 43 rule 1 or
What do you say, Mr. Isn't this an order under order 39? In view of section 37, it will be an order under order.
39. Court is granted temporary mandatory injunction. It is
Yes,
capital.
mandatory injunction can be granted, but whether it has been rightly granted or not, this court will consider if it is a foul.
Yes.
But not in a proceeding under 227. This is 227.
It is 115.
115 doesn't arise at all. How will you?
I understand that it comes within the ambit of other proceedings that is mentioned in 115.
Understood.
Because, my lord,
I accept,
why it comes,
but Mr. Counsel, I accept that. But how do you take care of the second proviso to section 115, which says that that can only be maintainable if that application which has been filed by the other side,
Yeah.
that is whoever, would have led to the disposal of the suit by you. Kindly see the second proviso to section 115.
the High Court shall not, under this section, vary or reverse any decree or order against which an appeal lies either to the High Court or to any court subordinate thereto.
Then there is another one.
A revision shall not operate as a stay of suit or other proceeding for the court, except as
The
such
first
or other proceeding is stayed by the head.
Please keep it. First proviso. Provided that the High Court shall not under this section vary or any order or any decision in this course of a suit or except where the order, see, if it is been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings.
So, in my mind, my lord, it comes that it is covered under other proceedings, as because filed under section 39.
Hmm.
That's why I have filed. I may be wrong, my lord. That's why I have filed under section 115. Because suit is there, in the suit there is no prayer for mandatory injunction.
No, you see,
Separately, it is filed there.
no, you see, section 39 application. Section 39 application would be an application in terms with order 39 1 and 2.
Yeah.
If that be so, it would not have dealt with disposal of an application of an injunction would have led to the disposal of the suit. One. That order 39 proceedings cannot be said to be an other proceeding. The other proceedings which are outside the scope of the suit. Just for example, a section 47 application. Or an application under order 39, order 21, rule 97.
Yeah.
These would have, you may file an application. Just for example, that day I got a matter where an order 21, rule 97 application was filed. The other side filed an application under section 47. The other side filed an application stating that this order 21, rule 97 application was not maintainable in view of the fact that the application was filed by a transferee pendent late in view of order 21, rule 102. In that view of the matter, that application under 115 would therefore be maintainable because that would be another proceeding. Otherwise, if we construe these to be another proceeding, then Surya Devi's judgment is directly hit, wherein categorically said that you cannot file a 115 against an order passed under what you call injunction proceedings. The learned counsel, upon hearing the learned counsel, it appears that the order which has been passed by the learned trial court, which have been impugned in the instant proceeding, that is dated 6/4/2024 in Mize case number 1052/2023, arising out of title suit number 619/2023. The same is an appealable order. Accordingly, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant application with the liberty to file withdraw the instant application. He further submits that the withdrawal of the instant application should not prejudice the petitioner in filing appeal in terms with Order 43, Rule 1R of the Code of Civil Procedure. Taking into account that the said order which have been passed on 6/4/2024, which have been as impugned in the instant proceeding, is an order passed in exercise of the power under Section 39, read with Section 37 of the Specific Relief Act 1963, and in terms with Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908, this court permits the withdrawal of the instant application, and the petitioner herein would be at liberty to file an appeal in terms with Order 43, Rule 1R of the Code, challenging the said order. You have filed a certified copy here?
Yes,
No. Certified copy is here. The petitioner is also given, the counsel for the petitioner is also given the liberty to file an application before the registry of this court for getting the certified copy of the order which have been, of the impugned order which have been enclosed to the instant revision application. Upon such application being filed, the trial court, the registry of this court shall forthwith furnish the certified copy enclosed to the instant petition.
Okay.
Yes, Mr. D. Gogoi.
Let's, I have a prayer to be picked on Monday.
Why Monday? Good day.
Deliberations are going on.
We'll have it on Wednesday. Let the deliberation continue for another 2 days. At the request of Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, the matter stands adjourned to be listed again on 8/5/2024.
Okay.
None appears on behalf of the parties on court, taking into account the instant proceedings of the year 2016. This court dismisses the instant application for non-prosecution. Yes, tell me.
In this transfer petition, we have taken steps upon the respondent, but as he was a CRPS Jawan, he last conversation when we had with the petitioners, he stated that he was posted at Kashmir. So now whether his family is residing at the present address or not, we don't have that information.
What is the case for?
So
The divorce case.
yes,
Fantastic. We vacate the stay. And then the proceedings will start, then you serve it.
The petitioner
You
resides at
cannot
Bongaigaon.
say that for 8 long years you have not been able to serve.
No, we have taken steps, but the notice was not served.
I can't help you.
But we tried to contact with
You
her
get the
client.
matter dismissed for default there.
We even don't know that what is the
This
status of
court is
the,
not going to extend this interim order out there. Nothing doing. This has been going on from here. You want it from Borpeta to Bongaigaon.
yes, sir.
So, how can this court pass an order? After 8 years, you have not been able to serve it.
We have tried to contact with her client and we have tried to gather the information regarding the title suit, but we have no information. So I can
I'm
just
not
only
going to
pray
say
for
anything. And
3 weeks.
and what is the stage of the proceedings there?
No idea.
This court. Your name?
Miss A. Bora.
Miss A. Bora, the learned counsel appearing on behalf of the appellant. Petition. This is an application under section 24 of the Code of Civil Procedure 1908 for transfer of title suit bracket M number 37/2014 pending before the learned principal judge family court Borpeta to the competent court at Bongaigaon on the ground that the petitioner is not in a position to travel to Borpeta for defending her interest in the aforementioned case. What is the ground? What is the ground?
She has no source of income, Lordship.
No source of income would not help you.
The distance is too much.
Huh?
Distance is too much and she has no one to accompany.
Not necessary. You go by yourself. And you don't need to go every day. It is in Guwahati, Borpeta. Go. Very well, very nice place. Go there. What are you doing?
I'm doing nothing, Lordship. I'm
Huh?
dependent on my parents. I'm dependent on my parents.
So, for last 8 years, you have been dependent on your parents.
The presence, I don't have any information
Huh?
regarding the presence.
This court have duly perused the grounds on which the instant transfer application has been filed and is of the opinion that the same does not merit a transfer. Accordingly, this court dismisses the instant application. The interim order dated 21/3/2016 stands vacated, and the court of the Principal Judge Family Court Borpeta shall proceed with the adjudication of title suit M number 34/7/2014 in accordance with law. This court further observed that as the respondent herein is not represented, the trial court shall issue due notice before proceeding with the said proceedings. The registry shall intimate the learned trial court about the incident.
May I please,
Hmm.
Lordship, the engaged counsel for the respondent number 1. He perhaps is out of station. He is instructed me to represent respondent number 1 on his behalf. So Lordship may kindly allow me to represent respondent number 1.
What is this, Mr. You are challenging?
I'm challenging the order, Your Lordship, may kindly peruse the page. It starts
Page?
at page 80 here.
Page
80.
80.
Page 0. An injunction was granted. Later on, it was vacated. Lordship, may kindly peruse
Injunction was vacated.
vacated in the appeal. That is why
Why?
page 82 starts. May I read? The present appeal under order 43-1 are yes, with the parties must defend it by the affidavit 3 by the order 14/1922 passed by the Lanet Petitioner District case number 2. In
Mr. Deori, don't read all these things. That too before this court.
Yes, sir.
People will laugh. What was the injunction granted by the trial court?
It may kindly peruse page 63. Your Lordship. Page 63.
There is no dispute that.
I was about to. The operative portion is at Your Lordship, page 59, 58. That's it. 50.
What is the status quo business?
I was,
What status quo? What was the injunction you were asked for?
Your Lordship, I was functioning as the Dharmadhikari. However, Your Lordship, after this, the respondent number 1 became the Sattradhikari, he has stopped me from functioning. Your Lordship, may kindly,
Had stopped you from functioning.
yes, sir, it's continuing to work, Your Lordship.
So then
That is why he has corporate action.
Then what you had, that means you are still stopped.
I don't think we are.
Then what remains? How will the status quo order be in your favor? If you have already been stopped prior to filing of the suit, you are already stopped.
No, at that point, we are not stopped here.
When were you stopped?
After this order, Your Lordship, may kindly peruse the appeal order, Your Lordship. Then we will stop here.
What are you asking for? For declaration that the plaintiffs are doing acts against the this is the counter claim.
Page,
Wait. Where is the plain?
Your Lordship, it page, it starts at page
If you are reading for
9.
the plaintiff has every right, title, and interest in utilizing the Bornamghar, Manipur, so and so, to facilitate in administering Saron and Bhajan to the devotee of the Satra come from different Iman. Declaration that the plaintiff number 1 as Dharmasaya has equal standard, honor, Iman, so and so, issue for restraining the defendant, including any act of prohibiting, interfering the plaintiff in using the Bornamghar and so and so of the Satra in administering the so and so. Now 13 and 14, paragraph 13 and 14 at page 34. What is it? Read it.
Yes, sir.
You have already been denied,
Yes.
for which you are seeking a declaration. Then how will the status quo help you?
Your Lordship, by giving the status for Your Lordship, may kindly peruse the order.
By giving the status quo, they allowed you.
Yes, Your Lordship. Not only that, Your Lordship, may
How can the status quo allow
no,
you?
no, Your Lordship,
And further to that, the First Appellate Court duly takes note of that the status quo with order which was allowed was is absolutely vague. See the order passed by the First Appellate Court, which
Yes, sir.
categorically says, I agree with the submission of the learned counsel for the appellant that the order dated so and so are ambiguous. By the order dated so and so, on one hand, trial court had directed the parties to maintain that he is not allowing the respondent to administer Saron so and so, and at the same time has restrained the heir from unauthorized obstruction of so and so. Where is the order of unauthorized obstruction?
no, Your Lordship, may kindly peruse page 46.
Page 40.
46. 46.
Yes.
Mary. The petitioner came up with an instant case praying for issuance of an order of interim injunction, temporary injunction, restraining
No, this is what he has written, but what is the order? Hence, both the parties are directed to maintain status quo and they are restrained from unauthorized obstruction of so and so. And if you are, what is wrong with the trial court, the first appellate court's order? You pass an order of status quo, wherein in paragraph number 13 and 14, it is categorically mentioned that they have debarred you from doing everything. And on the other hand, you restrain them, the appellants or the respondents herein, from unauthorized obstruction of here. Are you not giving a right when you are still, when it has already been here? Isn't that amount to a right being conferred by the court at the stage of a temporary injunction? More right which was not there. I would have understood a restraining order, maybe. But this is actually not a restraining, it is more like a mandatory injunction.
my respectful submission. I beg to differ, Your Lordship, because here, Your Lordship, is
Clefo, clefo, clefo. This is an application under section 115.
Yes.
Yeah, how 115 is maintainable?
because it's a order against the appeal, Your Lordship. I'm telling you the point.
Absolutely no. None, Mika. This is an application under section 115 of the Code of Civil Procedure, challenging the order dated 21/12/2022 passed in connection with Miss Appeal number 87/2012, by which the learned additional District Judge FTC Dibrugarh had set aside and quashed the order dated 14/9/2022 passed by the Civil Judge Dibrugarh in connection with Ms. J case number 57/2022 arising out of title suit number 96/2022. From the materials on record, it transpired that the petitioners herein as plaintiffs had instituted a suit before the court of the civil judge at Dibrugarh, which was registered and numbered as title suit number 96/2022. This court finds it very pertinent to reproduce paragraph 13 and 14 of the said plaint, page 34 of Kapati. Above reading of the said plaint categorically shows that a plaintiff, since after the adoration of the defendant number 1 on 15/2/2022 as the 28th Satradhikar of Dinjoy Satra, denied the right of the plaintiff number 1 to administer Saron and Bhajan to the devotees inside the Satra Namghar from taking bath in the Borpukri and from bow down before the Singhasan of the Satra Moniput, that required before initiation of the Saran and Bhajan for both the Dharmacharya and devotee come to Saran and Bhajan. It was further mentioned that such illegal and unauthorized obstruction of the defendant started the next day of adoration of the defendant number 1, that is from 16/2/2022, and continued till date. Therefore, it is very clear that as on the date on which the suit was filed, the petitioners herein were not permitted to administer Saran and Bhajan to the devotees inside the Satra Namghar, or from taking bath in the Borpukuri, as well as from bow down before the Singhasan of the Satra Moniput, which is required as per the plaintiffs for initiation of Saran and Bhajan for both the Dharmacharya and the devotee come for Saran and Bhajan. Full stop. It is under such circumstances the suit was filed seeking declaration that the plaintiff number one has due rights to administer, to utilize the Bornamghar, Moniput, Borpukuri, and to administer Charan and Bhajan to the devotees of the Satra who come from different villages under the Satra, semicolon, for a declaration that the plaintiff number one as Dharmasajya has equal standard, honor, dignity, and entitled to equal facilities with that of the defendant number one, the Satradhikar of the Satra, and for a permanent injunction restraining the defendant and the persons working under them from doing any act or things towards prohibiting, interfering the plaintiff number one in using the Bornamghar, Moniput, and Borpukuri of the Satra in administering the initiation of Charan and Bhajan to the valued devotee come from 136 number of villages under the Dinjoy Satra. Along with the suit, an injunction application was filed, which was registered and numbered as Mizje case number 57/2022, seeking temporary injunction in tune with the injunction in tune with the permanent injunction so prayed for in the suit. The learned trial court, by an order dated 16/3/2022, directed both the parties to maintain status quo over the matter in dispute and further restrain the opposite parties from unauthorized obstruction of the petitioner, particularly the petitioner number one, from utilizing the Bornamghar and Moniput for administering initiation of Charan and Bhajan to the devotee of Dinjoy Satra, as well as from using the Borpukuri of the Satra by the disciple that required to bath before initiation, who came for Charan and Bhajan till the next day. Thereupon, the written objections were filed, and further to that, written statement was also filed by the defendants along with the counterclaim. The learned trial court disposed of the said injunction application by an order dated 14/9/2022, and to the surprise of this court, the learned trial court observed that the order dated and to the surprise of, and the learned trial court observed that the interim order of status quo dated 16/3/2022 be continued till the disposal of the suit. Being agreed, an appeal was prepared, which was registered as Miss Appeal number 87/2022 by the defendants, who are the respondents herein. By the order dated 21/12/2022, the Miss Appeal number 87/2012 was allowed by setting aside the orders dated 16/3/2022 and 14/9/2022, passed in Mizje case number 57/2022. It is under such circumstances the present petition has been filed, challenging the impugned order dated, challenging the order dated 21/12/2022. This court I've heard Mr. T. Dewry, the learned counsel, appearing on behalf of the petitioner, as well as Mr. A. Chaudhary, the learned counsel, appearing on behalf of the respondent, and have given due consideration to the above aspects, to their respective submissions. This court had duly taken note of the judgment, the order passed by the learned first appellate, duly taken note of the orders being passed by the learned trial court as well as the first appellate court. As already noticed herein above, at paragraph number 13 and 14, the plaintiff had categorically mentioned in their claim that they have been already, they have not been allowed to act as the dharmacharya and administer Saron and Bhajan inside the Dinjoy Satra premises at Dinjoy Sabua since 16/2 2022. This court, upon perusal of the impugn order of the learned trial court, dated 14/9/2022, this court, having perused the order dated 14/9/2022, passed by the learned first step trial court, finds it very pertinent to observe that the learned trial court, on one hand, directed the parties to maintain status quo, meaning thereby the petitioners, the plaintiffs who were debarred from exercising any right as dharmacharya or administering Saron or Bhajan inside the Dinjoy Satra premises could not have act as the dharmacharya and administer Saron and Bhajan inside the Dinjoy Satra. And on the other hand, had restrained the opposite party to interfere with the right of the plaintiff to act as the dharmacharya and administer Saron and Bhajan inside the Dinjoy Satra. The said order, on the face of it, was contradictory in nature, apart from the fact that the learned trial court in the injunction proceeding had almost granted the final relief. The learned first appellate court have duly taken note of the said aspect of the matter, as could be seen in paragraph number 9 and 10 of the said of the impugned order. This court, having perused the said order, the said paragraphs, is of the opinion that the learned first appellate court duly exercised the jurisdiction conferred upon it, taking into account that the order passed by the learned trial court dated 14/9/2022 was on the face of it arbitrary, illegal, unreasonable, irrational, as well as in violation to the well-settled principles of grant of an injunction. Consequently, this court finds no ground to interfere with the impugned order dated, impugned order dated 21/12/2022, for which the instant petition stands dismissed. Yes, what is this?
Application under section 82 of the Employee State Insurance Act.
Then,
Against the judgment order of the Act.
whether the substantial questions of law,
Follow the law, type state
where?
paragraph 1.
Where?
It's a memo of April 1.
Where are the substantial questions of law?
1, 2, 3. These are the grounds. The grounds only mean that.
The learned counsel appearing on behalf of the appellant is directed to formulate substantial questions to draft to place before this court the proposed draft substantial questions of law which can be framed in the instant appeal. Formulated it. List the matter up to.
The HCR may be
What?
The lower court.
Why?
40.
First, let me admit,
Malad.
I have not admitted it. You are to place before this court a set of substantial questions of law. Do that. Then only we can. Yes,
Lordship, this is appeal under section 30 of the Employees Compensation Act. The subject question of law are at page 8. There was no employer-employee relationship, which is requirement as per section 3.
there is no employee relation between the respondent and. How do you say? Employee relation is not there?
Because in his evidence, Lordship, he was traveling in the vehicle with some cement bags of a person from Hing who had ordered those cement bags. And in his cross-examination, he accepted that this Moy Hing Pora Poisa Pai, the person who took the cement bag from him, he got the money. So he was a labor of that person, not of the vehicle. And the owner also did not appear and said that he was employed by this person. মই ঢিং পাৰ্টিৰ পৰা পইচা পাইছিলো মাল লৈ গলে পইচাটো দিছিল।
Kindly see paragraph issue number 1, page 5, internal page 5 of the order.
The
Yeah.
claimant petitioner deposed that he was employed as labor of vehicle number 20 under them. That is what we are charging. That is what
No, you can't say that. Kindly read it.
employment of opposite parties. Since
On the other hand, opposite party did not adduce or produce any evidence to disqualify the employment of the claimant as he had stated in the claim petition that he was employed as a labor of the offending vehicle. It could not disqualify the employment of the claimant since such it is adequately proved that the petitioner was employed in the above noted vehicle and therefore he is an employee as pursuant.
Lordship it is for the petitioner to prove that he was employed. In cross-examination, he says, I was paid by some other person, not by the employer. Then how that itself proves we do not need to give
So
evidence.
does your substantial question of law,
Yes.
which you have framed, does it suggest anything to that effect what you are submitting?
Lordship, these are my draft. Lordship can
Yeah.
but Lordship will be
The learned
formally
counsel appearing on behalf of the appellant is directed to produce frame the Miss R.D. Majumdar, learned counsel appearing on behalf of the appellant, submits that she requires a week's time for submitting fresh substantial questions of law in the matter.
and Lordship, we may be allowed to present the evidence also.
Why?
Lordship,
First, you have to show that, and you may show it. You may show it.
I
You don't
can
need
just
to file anything.
Lordship,
You don't, you just get me a piece of paper.
I
for that.
have
And evidence that you can show me that yes, he said that I was not employed, but he said out there in the crowd, the trial court had categorically held that he was an employee.
and that's why we are challenging. Lordship,
But
as a
your
question-
question of law should have been that on the basis of the evidence passed of so and so during the period which was taken, whether the findings so arrived in issue number 1 by the learned that court is perverse. That should
we
have
have
been your
mentioned that
substantial
I
question of.
that is my ground. That's what
You can't have it as a ground. That is the question of law.
I-
What question of law you are mentioning is a question of fact. Can you see? Issue number,
I-
the
I
first
got-
subject is
I
a
got
question of fact.
I got it. Lordship.
And
I'll just give it like that.
yes,
Fine.
don't need to file it.
Fine, Lordship.
Yes, what is this?
Lord, the petitioners prepared Lordship, Lord, the defendants in that dispute matter.
Hmm.
Dispute proceeded, the time of the evidence, the plaintiffs came and filed an application under order 9/14 for production of.
What application did he file? Order,
Lord, page
order 11 rule 14
14, my
for
lord, page-
production of document.
Page 44,
That was allowed.
it was not allowed, my lord.
Why?
That was asked in our favor, but while
I've entered the copy of the the document, so therefore the
For Lordship,
plaintiff
on page
complied with the
58,
requirement of order.
page
7
60.
15 while taking it. Statement. Let me check. Why you asking the defendant what is the dark number of your schedule B land?
My lord, the plaintiff are asking. Plaintiff's my. I'm the
You are the
defendant.
plaintiff.
Two pairs are there. First part is allowed. Second part was dismissed. My learned friend is here against first part.
First part,
My lord, if your lordship come to page number 64, what time is page number 60,
60.
60.
I've read it. Tell me.
As the last para, my lord. The
Secondary evidence.
defendants have
You are only think that you say that it is not there. Why the court should have granted them the liberty to produce secondary evidence?
exactly, my lord.
That's it.
That's my.
So what
No
is wrong?
formal application, not even a prayer.
There's no prayer.
No, my lord, no prayer, my lord. Even in the plaints,
Kindly
there is
peruse.
no pleadings, my lord.
Kindly peruse.
This will
My
only
application.
spoil the time.
Kindly
My
peruse.
lord. Not pro moto. Their prayer is totally
You
different.
make
my
an object. This.
Kindly
Yes,
peruse page number 45. Lordship. My
45.
application. Annexure 4, relevant part, paragraph 3. 45.
Where? Under the possession of the listed man which are so not denied by the Where is the
Yes,
Prayer.
my prayer for production of original document to adduce as primary evidence.
then why
in,
did
written-
the
in their
why
written
did the
statement,
court exercise the power under 65?
okay, in their written statement, they denied.
So-
They denied. And denied having possession. Kindly peruse my list of document I have filed and their written statement.
Why?
They denied that I have not mentioned that particular line. Under the possession of defendant. They also place a copy, Lordship. Your Lordship will find at page 57,
What are these documents?
blank space.
What do you want? What are these documents you are asking for?
That
Page
document
31,
never,
my lord.
no, document they have not filed. I have
5 to
filed.
9 as the copies of
5
the
and 9.
original of
I have
5 to
filed this
9.
with
5
that
is
copy.
copy of the notice. 6
25,
is the copy of the
2015.
FIR. FIR you get it.
The copy is,
Who is are they the government?
copy is with the list. I have filed that.
This one?
Next page. Lordship will find copy.
No, which are the documents you are asking for?
5 and 9.
Lordship,
Copy of
first
trade license
document
and
is
copy of-
notice issued by Family Counseling Center, Assam, under welfare, social welfare department,
To them.
served to them,
That copy was served by the family counselor to them.
to them.
Okay,
That
then,
is my cause of action.
then number 9 is copy of the trade license.
Copy of the trade license.
Whose
It-
trade license?
This is actually family property, ancestral
Whose
property.
trade license?
This
in
is
whose
my
name?
Father,
Father is whose?
father of the party, court party.
He is in possession.
Yes.
My lord, the suit is for the two schedules. Schedule A and Schedule B.
Hmm.
Schedule A belongs to our petitioner or petitioner. Schedule B.
Let us not, Mr. go to all these complications. Simple thing is 5 and 9 is the document.
Yes.
First is, did you receive a notice dated
No, my lord,
25
in the written
2015?
statements we have denied. There
No,
was denied,
no,
sir.
nowhere. Lordship will nowhere found any whisper regarding
Not-
any of the
Not
document.
even, my lord, they are saying there are cause of action. If a lord
No, the
comes-
court has also held that he have refused. You are not on appeal.
Lordship.
You are not on revision. The court in the impugned order categorically says one thing.
Page 60.
Where is that order?
Page 60. The operative.
Categorically observe, as the defendants have disputed the correctness of the plaintiff's statement that the document number 5 and 9 are under the possession and custody of the defendant, I am of the way no purpose is served. So you are not challenging this portion of the order.
Because
So under such circumstances, this court will accept that what the trial court says is okay. The only question before this court is, would the court have directed that these document number 5 and 9 can be produced by secondary evidence without the compliance to section 65?
yes, doctor.
That's
That,
all.
that ingredients are there. That ingredients are there.
When you have not asked also.
Doctor, section 5 requires
No, did you ask anywhere that look here, I want to produce, otherwise give me this permission for secondary evidence?
Yes, I can rebut my lord. If there any formal
Because
application.
there the requirement will be as to whether the ingredients of 63 is met.
that is, although that has not been mentioned, but that is available. If
Where?
your lordship kindly peruse the
Mr.
copy,
Ali,
that is produced mechanical process.
has the suit been stayed? Fantastic. Let us keep the suit stayed. Or you want to file an application? We don't say anything to that effect. We just set aside this order.
Lordship,
To that
section
effect,
65
5 to 9.
requires ground. Sections are
No,
65.
you are to, no, you have not
requires
mentioned.
specific prayer.
Mr. Counsel, you have not mentioned in your application that in the circumstances they don't produce, kindly permit me to give secondary. That was required. You have not done that.
If your lordship kindly peruse for a moment,
Okay,
my prayer portion,
Okay. Remaining is for Supreme Court to.
further we
This is
issue
an
by any other
application
order,
and,
any other order. So trial court is the best court to consider admissibility and relevancy of document. So being a trial court,
Mr. Counsel, can the trial court, can he put an objection that these documents are, tomorrow you are going to produce the photocopy? You may produce the photocopy because the original is with them. You don't have it. So you will produce the photocopies. Or now these photocopies, if you are going to produce it, you can put an objection in view of the secondary evidence being permitted.
that is part of the plan that has not been denied. The written statement is
The
before your
court
lord,
says so.
before written statement is before your lordship.
I'm not going to look. This is an application. You file an application under 65.
Only liberty is given. So I will
No,
follow
no, in the
rest.
circumstances, the plaintiffs are liberty to
Only-
adduce secondary evidence.
Only
Means
liberty.
you have already been given the liberty to adduce secondary evidence.
I will adduce secondary evidence with due process. Lordship. Only liberty is given.
Where is the due process line?
No, that is not there.
Then? Oh, this is an application under Article 2 to 7 of the Constitution. Challenging the order dated 7/8/2023 passed by the learned civil judge number 3 Kamrup Metro at Guwahati in petition number 180/2023 entitled suit number 104/2016. Full stop. It is the case of the petitioner herein that the order which have been impugned in the instant proceeding is being challenged only on a limited purpose, to the extent is only on a limited scope, to the extent that in an application under Order 11 Rule 14, wherein the plaintiff has sought for a direction upon the defendants to produce the certain documents, the learned trial court, while having not directed such having not passed any direction against the defendants to to produce those documents, could not have permitted the plaintiff to adduce secondary evidence of the document number 5 and 9, that too without following the procedure in terms with section 63 and 65 of the Indian Evidence Act 1872. This court have duly heard the learned counsel appearing on behalf of the petitioner and have given a thoughtful consideration to their respectful submissions. This court have also perused the application under Order 11 Rule 14 filed by the plaintiff who are the respondents in the instant proceedings. From a perusal of the said petition, it revealed that the plaintiffs have sought for production of a direction upon the defendants to produce the document number 5 and 9, that is, the copy of the notice dated 25/2015, as well as a copy of the trade license dated 19/2008. The originals which the plaintiffs claim were in possession of the defendants. The learned trial court, be it as it may, it is very pertinent to observe that in the said application there was no prayer or even a statement to the effect that in the circumstance that no directions is passed, the plaintiff may be permitted to adduce secondary evidence. The learned trial court, by the impugned order, came to a conclusion that the defendants had disputed the correctness of the plaintiff's statement that the document number 5 and 9 are under the possession and custody of the defendants. The learned trial court, therefore, came to an opinion that no purpose is likely to be served by directing the defendants to produce the same, as apparently the defendants have denied possession of the same. Under such circumstances, in the opinion of this court, the trial court ought to have concluded the matter on the application under Order 11 Rule 14 of the court. Be that as it may, without even a statement made in the application, as well as a prayer made in the without any pleadings or relief sought for in the application under Order 11 Rule 14, the learned trial court granted the liberty to the plaintiffs to adduce secondary evidence of Exhibit 5 and 9. This court finds it very pertinent to take note of Section 63 of the Indian Evidence Act, which stipulate certain conditions under which secondary evidence can be permitted. When such an application is being filed, under such circumstances, when a request is being made to adduce a secondary evidence, then the respondent, the defendants, duly has a right to object to the same. However, with the learned trial court, in the instant case, even without taking note of the requirement of Section 63 and 65 of the Indian Evidence Act 1872, have passed such a direction. Accordingly, the impugned order dated 7/8/2023 is interfered with only to the extent of granting the liberty to the plaintiff to adduce secondary evidence of Exhibit 5 and 9. This court further clarifies that the above order, the instant order, shall not preclude the plaintiffs to file appropriate applications for adducing Exhibit 5 and 9 as secondary evidence by way of for adducing secondary evidence of Exhibit 5 and 9.
Not exhibit, document.
Huh?
Evidence is yet to be filed.
Okay.
Documents 5 and 9.
However, it makes it very clear that clarifies that the instant order shall not act as a bar on the part of the plaintiff to file an appropriate application to adduce secondary evidence of document number 5 and 9, that is the copy of the notice dated 25/2015 and the copy of the trade license dated 19/2008, or to prove the said documents in any other manner permissible under law. The order dated, taking into account the above, the order dated 29/9/2023 passed by this court is vacated, and the parties who are duly
17.5
represented are directed to appear before the learned trial court on
17.5, that is fixed.
Next date is 17/5.
17/5/2024.
Hello.
Take this, Mr. This book.
Yep.
Yes. Oh, this one.
My lord,
Same matter.
my lord. My lord, rejected on the ground of limitation.
You have that earlier my judgment.
My lord, I have.
देखो, the instant appeal is admitted. Heard Mr. So-and-so, the learned counsel appearing on behalf of the appellant,
Appellant.
and Ms.
K.
K. Pukan appearing on behalf of the respondent number
Two.
Respondent number 2.
Performer.
For respondent number 2. The instant appeal is directed against the judgment against the order against the order dated 24 against the order dated 24/3/2022 passed in title appeal number 16/2021 by the court of the civil judge at Dhubri, whereby the appeal was dismissed on account of delay, and thereby confirming the judgment and decree dated 25/1/2021 passed in title suit number 236/2001 by the learned Munsif number 1 Dhubri. The instant appeal is admitted on the following substantial question of law: whether the first appellate court was justified in dismissing the application under Section 5 of the Limitation Act 1963 for condoning the delay without taking into consideration the order of the Supreme Court dated 10/1/2022 passed in suo motu writ petition C number 3/2020. Taking into account that the appeal is the substantial question of law is very limited. This court is not inclined to call for the records. This court further issues notice upon the respondent number 1. The petition appellant is directed to take steps upon the respondent number 1 by registered post along with in the usual process. You can take service by Dusty. The learning council, the appellant is further directed to take steps by way of Dusty, routed to the registry of this court and list and file an affidavit of service on or before the next date. List the instant appeal on. Let's do it on month of May, 31st of May. I'm here till then. 31st of May 2024. Full stop.
Apply.
Yes,
Please, the Lord,
first time.
first time.
Yes, what case?
Question of law is 8 and 9.
How did you escape 11,011? Oh, that matter.
Lordship.
1155.
No.
Landlord tenant.
Landlord tenant, but what the court below enter into the examining my sale deed and all. Whether that.
You are the owner.
I am the owner. I purchased plot of land in which they were in occupation at the time of purchase. So trial court held that all those things is not written in the sale deed.
What are the substantial questions of law you have come up?
8 and 9. Okay, 1, 3, and 5 will be written.
Mr. Counsel, getting one substantial question of law admitted in this court is
Sufficient.
big. Don't come up with P4.
Sure.
What is it?
Lordship, Lordship, section 8 of the Trespass Property Act, everything trespasses along with the whatever has been in the
What did the trial court hold?
so
That there was no transfer.
no, there was it was not encumbrance fee because the tenants were there and that was not written in the sale deed.
Huh?
That was the trial court in my sale.
No, what did the first appellate court hold?
After that,
Let's see.
the discussion is relating to Lordship issue number 4. Let's start from page 29. What will find the
My decision, page 52.
page 50 is appellate court.
What does it hold? Arguments forwarded by
My
whom?
reason, my
decision.
reason and
What
my
is the
decision
first point for terminating? My decision is I have perused the order and documentary evidence that is fully and part of the plan was never agree with the view. Questioning the title of the landlord because he is a coon. But because according to the tenant plan, the land of tenant was never sold that property. The deed decision applies. Does not include the execution. If obtained, then here it will
The court also held that detail is not telling. The deed contain the whole land and the plain contain only the room, description of the room lot.
now in your plane, did you mention where the room was situated?
It was that
100% you must not have done.
page 14. One top. So certainly the room description has to be given.
No, it is there.
Okay.
He has only gone into the question of boundary,
Boundary.
standing on the part of 10 lessa of land under tag number 588 of periodic patta number 20. Why he has not considered that?
Not. That's, you have to have considered.
That over a period of time, people living in the boundaries may change. However, when the identity of itself has been challenged, it was incumbent upon the yard to prove the true property and the land sold to him on. And if they say, then it must be another pertinent collected land. To the previous combination. When there is a denial of tenancy, where is the notice on the 106 required? Not required. Does it require? There's a Supreme Court judgment on that. Don't require notice when your tenant you are denied. Therefore, the instant appeal, her the instant appeal this is an appeal under section 100 against the filed against the judgment and decree dated
367.
where 3/6/2017 entitled appeal number 13/2012, whereby the appeal so filed by the appellant herein was dismissed. The instant appeal is admitted by formulating the following substantial question of law. Whether the learned trial court, whether the learned first appellate court was justified in coming to a finding that the plaintiff oblique the finding that the appellant herein was not the landlord on the basis of just examining the boundaries mentioned in the plain with the boundaries mentioned in the sale deed,
Exhibit 1 and Exhibit 1 and
exhibits 1 and 2, without taking into account the entire schedule mentioned in the plain. Any more? Issue notice, returnable. So then you become landlord. Then the next thing is do you require the 106? Question does not arise. They also say that they don't arise. So I think this is enough. Issue notice to the respondent. How many respondents?
One.
Issue notice to the respondent. Step be taken by way of registered and you
2.50.
call for the LCR.
2.
1 and 2. Call for the LCR. List the matter upon completion of service as well as the receipt of service.
Apply.
Notice, issue notice 4 weeks, returnable by issue notice to area. তলত একটু লিখিছো that will be listed after or notice making it returnable by 6 weeks. itu না লাগে এই তলৰ লাইনটো না লাগে to be listed after
Next, what is with regard to the this, and along with it, accident also affected this.
the grandmother
Grandmother,
Huh?
grandmother,
so this is the matter pertaining to guardianship.
right.
Pursuant to the order dated 10/4/2024, due steps have been taken by way of the state upon the sole respondent. And in that regard, an affidavit of service has also been filed on 29/4/2024. This court have duly perused the said affidavit of service and taking into account the content as well as the annexure 1 to the said affidavit of service, this court deems the service upon the respondent number 1 respondent to be complete. However, today the respondent is not represented. For the end of justice, the matter stands adjourned to be listed again 25/2024. 20. On the said date, if the respondent is not represented, the matter shall proceed ex parte. Interim order passed on 19/2/2024 shall continue till the next day.
Complaint may not take it.
Yes, what is this?
Lordship, I have no objection, Lordship. They represent me well, Lord, because their case is that WS is rejected. It was within time.
Within time.
Within time.
In fact, your
No, within not one time was granted.
time was granted, but on the next day when I was about to submit my written statement, the impugned order is at page 40. I was allowed by order dated 6/11/2023 on page 38.
Hmm?
The council has some bereavement. Your order will kindly come to page 38. Page 30. The adjournment petition was filed because there was bereavement in the council. The next day, the 6/7, when he went.
This is an application under section Article 2 to 7 of the Constitution, challenging the order dated 11/12/2023 in title suit number 370/2023 in the court by the Court of the Civil Judge, Junior Division number 3, Kamrup Metro at Guwahati, whereby the written statement so submitted by the defendant was rejected on the ground that the statutory period of 90 days had elapsed. This court have duly taken note of the order dated 6/11/2023, whereby the defendant was permitted to file the WH on 11/12/2023. On 11/12/2023, accordingly, the defendant filed the written statement. However, the learned trial court rejected the said written statement on the ground that the summons were duly delivered to the defendant on 9/8/2023. Taking into account that the defendant was duly permitted to file the written statement on or before 1/11/12/2023, which is a part of the record of title suit number 370/2023. In the opinion of this court, the order dated 11/12/2023, thereby rejecting the written statement of the defendant, was not called for. According, the impugned order dated 11/12/2023 is interfered with and thereby directing the learned trial court, that is the court of the Civil Judge, Junior Division number 3, Kamrup Metro at Guwahati, to accept the written statement filed by the defendant and then to proceed with the suit in accordance with law. The order dated 29/2/2024 passed by this court stands vacated, and as the parties are duly represented, they are directed to appear before the learned trial court on 1st of June 2020.
Forty-two.
Yes, what is this?
Fix the matter at two.
Huh?
Why can you let it vote it?
Need senior. This court have pursuant to the order passed by this court on 11/3/2024. It revealed that the steps upon the defendant have been duly effected. By way of the state, as could be seen from a perusal of the affidavit of service profile, wherein it has been mentioned that though the respondent was not present in the court, present in his house, but his daughter-in-law has accepted the notice by putting her signature in Annexure A. So, taking into account the above, this court deems the service upon the defendant, the respondent, herein to be complete. However, as the respondent is not represented today, the matter stands adjourned to be listed again on 10th of June 2024. On the next date, if the respondent is not represented, the instant matter shall proceed in their absence. The interim order passed on 11/3/2024 is extended till the next.
Item 12 forward.
Hmm.
But that I have filed it. It is ready for filing. But
What?
many appellants have died, Lord. So I have drafted the submission, it is ready for filing. And the deponent has ordered the train yesterday, but due to breach in the railway track near Haplong, Lordship, today he cannot.
When did the appellant number 1 expire?
Appellant number 1. He expired in 77, Lord.
Huh?
2007, sorry. 2007. I was not the counselor here. I am getting case after.
So this appellant number 1, how many appellants are there?
Appellant for Lordship. 8.
Huh?
8, Lord.
What? 8.
Appellant.
8. How many appellants? Appellant number 1 expired.
Lord. And you don't prefer only one due to breach in railway track, Lordship, deponent could not get.
But you informed this court on 3/1/2024 that the appellant number 1 had expired.
Before that, the parties had not contacted us.
So how can I help you? No, you only said the party did not contact you. It's different.
No, Lordship, repeatedly, ultimately, I had issued the retirement.
29/11/2023, Learned Counsel for the appellant submits the sum of the appellants have in the meantime died and their substitution is necessary. How do you take care of these
Lordship,
situations? How many appellants have died? 8,
Four-
9,
four-
2023.
Four
Some of the appellants have expired. Yeah, you knew about it. And why have you not filed till now?
Lordship, I have requested the client many times, and when I took
So they are not bothered.
send the retirement letter,
How many? Out of 8, how many have died? Who are alive?
four had died, and four are out of 8 numbers, Lordship, 4 are alive, 4 had.
Who are the 4 who are alive? You have said that you have filed an application.
No, it is ready for filing.
It is there. Who has died? If it is ready for filing, it will be mentioned who are the persons who died.
Appellant number 1, Lordship,
Ah,
2,
ah.
and 6, 8. They have it.
Appellant number 1,
2,
2,
6,
6,
and 8.
8 died.
Lordship.
When?
They died, Lordship. Number 1 on 29/7/2007. Lordship.
29/7/2007.
And then Lordship, number 2, 16/6/23.
16/6/23.
And number 6, Lordship, expired on 18/1/2006.
18/1.
2006.
Number 6.
Yes.
And
And number 8 expired, Lordship, on 25/5/2005.
25/5/2013.
I was not counted yet.
No, it's not that it is. I am saying that it is your mistake. You came later on.
Right.
But what is the decree which has been passed?
It has been passed for the declaration that that's giving.
Eviction of these appellants.
We allowed to
And
file.
everybody has a separate right.
Yes, sir. Separate.
And who is 6 and 7?
6 and 7, Lordship.
Both are daughters of late Santosh Kumar Nath. 8 is also wife of late Santosh Kumar Nath.
6 is the daughter, Lordship. 8 is the wife of late Santosh Kumar.
So the daughter as well as the heir had died.
Sure.
Because you what is the substantial question of law?
Page 8, Lord. Memo. Right title interest was decided, Lordship, without claiming any issues.
Mr. Roy, you need to check the record. These are not the questions of law framed. There are 4 questions of law framed. Whether both the courts below are justified in dividing the landed properties of the appellant plaintiff amongst the brothers in absence of any pleading. You are a plaintiff.
Lordship.
Huh?
No, I am in dispute, I am the defect. Sorry.
Okay. It has been submitted at the bar by Mr. S.P. Roy, the learned counsel appearing on behalf of the appellant, that the appellant number 1 expired on 29.
Expired on Lordship 29/7.
29/7/2007. Semicolon. The appellant number 2 expired on 6/6/2023.
16/6.
16/6/2023.
Good.
The appellant number 6 expired on 8/1/2006.
18 Lord.
18/1/2006. And appellant number 8 expired on 25/5/2023.
2005.
2005. This is before the appeal was filed. Huh? Are you sure? Appeal was filed 2004. Okay. 2004. Appeal was filed in 2nd of September 2004. There must have been some delay.
Delay. That was found out. Then what happened earlier? The learned
It is
counsel-
also seen from the records that on 8/9/2023 itself, it was duly submitted before this court that some of the appellants had expired. On various occasions thereafter, the the appellants have been taking time for taking steps. Today, Mr. S.P. Roy, the learned counsel, submits that they are in the process of filing appropriate application during the course of the day.
No, Lord, by Monday, because it due to breach in the railway track near Haplong. The opponent had
Then we have waited.
Sure.
The appeal waits insofar as good. Are you filing it during the course? Don't make this type of submission. This is a
No,
2005 second appeal.
to breach in railway track. He was supposed to reach today morning.
And
Monday, give me time on Monday.
it's going to file the applications by Monday. That is on 6/5/2024. 24. List the matter again on 10/5/2024.
Right.
Item 13.
Your line one.
May I please start?
Yes.
My lord, as per office note dated 1/3/24. Appears that the LCR of the title is not in.
Whatever service is complete.
Yes, ma'am. The respondent is there.
The office note shows that the LCR of title suit number 39/98 has not been received. The registry shall take appropriate steps for obtaining the LCR. This court have also taken note of the communication issued by the by the civil judge and assistant session judge Karimganj. The registry shall take appropriate steps to do the needful, taking into account that the instant second appeal has been pending since 2007. It's the matter after 6 weeks.
I have obliged.
It is the left side. I file sufficient of the picture. But there is some effect of it.
When did the person die? How many appellants? And he died. You have not filed substitution.
We have already filed.
When? When?
I have filed it here, but there is some
You
effect.
said in June 2023 you have filed. Are you sure? Where is the number?
Again, give it 8060,
The learned counsel appearing on behalf, Mr. R. Sharma, the learned counsel appearing on behalf of the appellant submits that 3 applications have been filed, being IA
8060 of 2023, 8061 of 2023.
on
On the month of April,
have been filed. Full stop. The registry shall make necessary inquiry into the same and list the matter of 2 weeks.
okay.
By submit. If no such application is filed, the registry shall place necessary, shall mention in the office note.
The officer is checked.
You have filed.
Yes, number is also.
Let them take. Defective.
Yes, I
Why have you not corrected it?
taken my card payload.
Oh. এখন dismiss করুন। Nothing doing. How can it be defective for such a long time?
The case is not that
No, not listed. Forget about that. When you file, isn't it your responsibility?
I'm thinking that it is correctly right. So,
Is there stay operating? No, stay
I
আসেনি।
think-
Stay যদি আসে vacate করে দিন। হ্যাঁ? যাও। মানে? What is the decree for?
if you are 50% of contract for execution of a sale deed,
Then
the defendant is already in possession of the plan. The defendant is in possession of the plan. Still,
sale deed,
sale deed, but if it is for execution of sale deed, I have filed the appeal. That is not right.
you are the plaintiff.
I have the defendant.
Has the execution of sale deed happened?
No.
Yeah. চলো। একটু আগা ওঠাতে পারো। This court have duly taken note of the office note 84/4/2024, wherein it has been mentioned that 3 interlocutory applications have been filed, being IAC 8060/2023, IAC 8061/2023, and IAC 8062/2023, and which have been lying defective since the date of filing. Mr. R. Sharma, appearing on behalf of the appellant, submits that those applications were filed sometime in the month of June 2023. This court is shocked and surprised that the defect have not yet been removed, even after a period of 10 months.
So I shall move it back. Please.
Under such circumstances, this court fixes the matter again on 10th of May 2024.
Then I shall not be able to take some other. To then I
13th of May, unlucky date. Okay. 13th of May 2024. on which date if the defects are not removed, by which date, and if the defects are not removed prior to 10/5/2024, this court shall pass appropriate orders. They are observing that the said application are honest and cannot be taken into consideration. This court further observed that there is no stay order, although the appeal has been admitted. Accordingly, the respondent herein would be at liberty to proceed with the execution of the said appeal, said judgment and decree passed by the learned trial court. Yes, what is this?
Lordship, I'm appearing on behalf of respondent three lordship. Lordship, appeal has already been abated. Lordship.
Huh?
Appeal has already been abated, Lord.
None appears on behalf of the appellant on call. Mr.
M. Boro, Lord.
Embora appearing on behalf of
Boro, Lord.
respondent
Yes, Lord. Respondent three.
submits that the appeal has already been abated in view of the fact that all the appellants
No, Lordship. Lordship, abated against respondent number one, Lordship.
had abated against the respondent number one who expired on.
Actual date, I have not been informed.
Don't make
Lordship.
that submission then, cut off. None appears on behalf of the appellant where the matter is listed. The office note shows that on 21/3, office note dated 21/3/2024 shows that no fresh wakalatnama has been received on behalf of the appellant, as well as no substitution application also filed insofar as the respondent number one. This court further takes note that the service report, the office note dated 28/8/2018, wherein it has been shown that the respondent number one had expired. Under such circumstances, as no steps have been taken, the instant appeal abates insofar as the respondent number one. This court takes up the matter, would further take up the matter on 13th of May 2024. If the appellant is not represented, the instant appeal shall be dismissed for non-prosecution. Yes.
May please, your lordship. Office note dated 12/12/26 shows that lordship sole respondent expired.
Then?
So, lordship, I have time to contact my client, lordship. I have sent a letter, lordship, but I have not received instruction, lordship. So I have to substitute the legal as the sole respondent.
So you knew it. That yeah, you have taken steps. Yeah, but 3 months have gone.
Yes,
Appeal
lordship.
has abated. Nothing remains. I can't help you.
I am paying some time.
It appears from the records that in the office note dated 12/12/2023, it has been reflected that the sole as a respondent had expired. On 3/1/2024, when the matter was listed, the counsel appearing on behalf of the appellant sought for time to obtain instructions and to take appropriate steps. And accordingly, the matter stood adjourned for 4 weeks. A period of 3 months have already expired post 3/1/2024. Accordingly, the appeal automatically, by operation of law, stands abated and according and consequently closed. Yes, what is it?
My lord, this time appearing for the first time, period of the record, I found that my lord, on my lord, 28 to 24, my lord, friend, my lord, found the court that response number 1 has expired. My lord, the circumstances, I may be allowed, my lord.
I have
substitute that-
informed in the year 2019, Lordship, to the earlier engaged. I have informed in the year 2019 that respondent number 1 died on 8/5/2019.
Came to know from the order sheet, my lord, for 28 to 24. New,
Where is it? There's no order out here.
No, Lordship, I have served notice to the earlier engaged counsel. They accepted that notice. So now maybe he is newly engaged, Lordship. And in the meantime, I have received.
Appellant number 2 had expired.
Yes, Lordship, that I have. Two, Lordship, appellant number.
Appellant number 2 had expired. You have not taken steps.
Respondent number 1 also died, Lordship, in the year 2019. And appellant number 2 also.
Respondent number 1 expired on 17/9/2019.
8/5/2019, Lordship.
Now you said out there, it is recorded out there.
Maybe wrongly
According to
recorded,
Ms.
but that
Chaudhary,
certificate
the
I am-
respondent number 1 had also expired and on.
I only came.
How many appellants are there? Who have expired? Kalika Bewa, Hazrat Ali,
Hazrat Ali expired, Lordship.
Mustana Malika Bewa, Mohammad Khatimud Sheikh have expired long back. So 2 and 3 had already expired. And 1G, 1A, and 1B. 1B, 1C, 1A, 1B, 2 and 3 have already expired. Then what remains? When? You made the submission earlier.
Lordship, respondent number 1.
No, petition. Appellant number 1A, 1B, 2 and 3.
No, only Hazrat expired, Lordship. Appellant
Why it
number
is being recorded out there?
1B, Hazrat expired. Lordship.
Anyways,
Lordship,
how many persons have you filed wakalatnama?
My lord, 3, my lord.
3, appellant number 3, 4C, and 4D. Who is 3?
3 is my lord, Hatimuddin Sheikh.
Is this Hatimuddin Sheikh? Didn't see any Hatimuddin. Three is Mohammad Hatimud.
Hati Mahmud Sheikh.
Mahmud. Are you appearing for that?
Yes.
No. He's dead.
Hati Mahmud Sheikh. Okay.
Yes. And who is 4C? There's no 4C business out there.
There is no food.
Then what is this 4C and 4D? There has been substitution.
There are some.
Hatimuddin is dead. Substitution has happened. He's appearing for 3. Abdul Sheikh. Everything has changed. What is this? Completed the appellant 4C. Amir Hussain. And Hirona Begum 4D. 4D. Sorina Begum.
There is some confusion, my lord, in appeal memo, my lord. Amir Hussain and Zarina Khatun is, my lord, 1D and
Appellant number 2 had expired. Now you are not representing them.
Well-
You have the alert number only for 3%,
yes, now
not others.
they have submitted now.
So none appears for them.
My lord, perhaps may come. But very recently, my lord, I had because
I'll
of
hand
this,
it over,
so
doesn't
many
matter.
substitution and so many, I also find a little bit confused, my lord, to represent the respondent.
We do you a favor by dismissing the appeal by holding that there is no substantial question of intent. Where is the appeal? Whether the further court misread the provision of Order 2, Rule 2, read with Section 34, and if so, what it will be the effect? How can that be a substantial question of law? Matter end.
On merit, I have not prepared them, my lord.
You are not
My lord,
prepared
may
for
I-
order, you are not prepared for merit. How do I help you?
My lord, may I pray, my lord, 1 week time may kindly be granted. I may
Okay.
be allowed to.
1 week's time is granted to the appellant, to Mr. D.K. Sharma, the learned counsel appearing on behalf of the appellant number 3, 4C and 4D. However, there is no counsel representing the other appellant. Mr. R. Chaudhary appears on behalf of
Respondent lordship. Respondent number 1 already died. And
respondent.
earlier I was appearing for respondent number 2A to 2D lordship and 1.
Appears
to-
for some of the respondents.
Some of the rest.
Only
Obliged,
list the matter after 2 weeks.
obliged.
Land. Delete your clear. Yes, what are the miscases for?
The office note dated 24/4/2024 that reveals that the service is not complete. But my lord, they are not necessary parties, my lord. I am
What are
very-
these? What is this IA for?
This is for substitution. But my lord,
Order 22, Rule 4,
my lord, my prayer is
11.
this,
For
They are the
substitution
proper
of the legal heirs of Timothy so and so as respond number 2-1 in miscase number so and so. What is this miscase business? Miscase why? It has not yet been condoned.
well, one person died. No, he filed a substitution petition. But at this stage, my lord, not a necessary party. They are proper dependent.
Oh, no.
So no relief claimed by the plaintiff against them. So they may be struck off.
Which one?
That is in second
RSC
appeal, your
con-
lordship will find
Where is the RSC?
respondent number 2, 3, and 4. The lordship will
Thing
find
has to be done with this substitution business. Thing is happening. Are these the appellant number 1 and 2 alive?
1 and 2 alive.
Okay. Now who had died?
Lord Timothy Mirarani Das. She is the proper
Respond number
defendant.
4.
Respondent number 2, my
Miradar 2. And then
and 3 and 4, my lord, they are there. But
1
they are all pro forma defendant. One is the main plaintiff.
there.
Yes, he-
You are paying for 1.
Yes, Lord.
he is
okay.
appearing for one.
2, 3 and 4 are dead.
They can be struck off.
The learned counsel, Mr. S. Dotto, the learned senior counsel submits that the respondent number 2, 3 and 4 are not that submit that taking into account that the respondent number 2, 3 and 4 were pro forma defendants in the suit and they did not participate in the trial as well as also in the first appellate stage, their names may be struck off. So taking into account the fact that these respondents have not filed any written statement and they have not participated in the trial as well as in the first appellate court, their names are struck off. Full stop. Accordingly, This court, LCA received, na? LCA is received.
No, there,
It has not yet been admitted.
no,
RSA number one, you know. Which case that means? How much is the delay? Like, the-
110 days.
Huh?
110 days. Sir.
এটা opposite party হ'ব দেই এইটো opposite party number 2 PN mistake this is an appeal তাৰপিছত accordingly deleted অফিচত লিখিব দেই This is an application under Section 5 of the Limitation Act 1963 to condone the delay of 110 days in filing the regular second appeal against the judgment and decree dated 9/2/2012 passed by the learned civil judge number 2 Pachar Silchar in title appeal number 22/2006. No objection.
Lordship, we will file our objection sometime.
You had the notice long time back.
Lordship, that is there.
Then what is this? Nothing is there. 2012 one has to finish it off. So, taking into account, this court have heard Mr. S. Dutta, the learned senior counsel, as well as Ms. So appearing on behalf of the respondent number, opposite party number 1. So, this court have also perused the cause shown as to why the delay of 110 days had occurred in preparing the appeal, which is seen in paragraph number 2 of the said application. So, taking into account the grounds which have been assigned in the opinion of the court constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act, and accordingly, the delay stands condoned. The instant interlocutory application stands allowed. The registry is directed to register the regular second appeal and list the matter for in the column of Order 41, Rule 11 on 17th of May 2024. This court further directs the appellants herein to file a fresh memo of parties before the registry in respect to the accompanying second appeal, taking into account that the names of the opposite party number 2, 3, and 4, who are also the respondent number 2, 3, and 4 in the regular second appeal, have been struck off. Opposite party number who are the respondent numbers 2, 3, and 4 in the accompanying second appeal have been struck off.
public.
I stand disposed, and the others are not pressed.
Yes.
Which other IAs you are not pressing? 3820.
Lord, please, IA
You must have
3820.
which IA is for stay.
My lord,
There is no stay.
3821 is for condoning delay.
Oh.
Then my lord,
एक one opening how
3820 for substitution.
एक one which
And-
is
3822 for setting aside abatement.
3821 is
3821 is for condonation of delay
for
of 315 days for substitute.
a
substituting the
substitution.
legal
So 3821, 3822, and 3820 all have become in.
Mine.
Taking into account the order passed in by our IA consumption of 2012, the 13, 12, the instant applications which have been filed for condonation of delay, setting aside abatement, as well as substitution of the legal representatives of
Mirarani,
the opposite party number 2
opposite party number 2, Mirarani Das.
does not survive. Accordingly, the 3 applications stands closed as it had become infructuous.
Obliged.
Why this matter? 1928. And appears on behalf of the appellant, repeats the TR. I could. This court duly takes note of the office note dated 24/4/2024. And from the said, it appears that FC civil case number 767/2015 was disposed of on 5/9/2016 by the Principal Judge, Family Court number 2, Kamrup Metro. Taking into account the above, this court observed that the order dated 27/3/2024 of dismissing the instant transfer application stands. However, the directions were passed to the learned Principal Judge number 2, Family Court, Kamrup at Guwahati, Kamrup Metro at Guwahati, to proceed with FC civil case number 1238/2015 is no longer required to be adhered to. In view of the office note dated 24/4/2024. The registry shall duly inform the learned trial court, the learned principal judge number 2 family court Kamrup about the instant order. Okay. The office note dated 29/4/2024 shows that no step that service upon the respondent number 1 to 4 is not yet complete. The appellant is not represented today. This court fixes the matter again on 27th of May 2024. In the circumstance, on the same date, if the appellant is not present, the appellant is not present, this court shall consider passing appropriate orders. Yes, what is this?
This was not clear. On 27, 21, 7 percent.
The learned counsel appear, the appellant is directed to take fresh steps upon the respondent by registered post as well as usual within 7 days. List the matter of the completion of service.
May I please? Lordship, as per official dated 6/3/2024, my lord. Respondent number 234.
Sir, your name MK Sharma.
MK Sharma, my lord.
Mr. MK Sharma, the learned counsel appearing on behalf of the appellant submit that taking into account the office note dated 6/3/2024, he would take appropriate steps as regards the steps in view of the fact that it has been shown that the appellant respondent number 1 had expired. Further to that, it is also seen that the service upon the respondent number 8 is not complete. The appellant is directed to take fresh steps upon the respondent number 8 by way of registered as well as usual within 7 days complete.
My lord. And the, sorry, sir. And is the respondent number 9 Roman 2, my lord. Respondent number 8 and 9 Roman 2 are same person.
You, who has made them? Same?
My lord, in earlier case, my lord, I've been engaged subsequently.
Then do what? You have to amend it. Otherwise, we will constitute these are
My lord,
different. A person may have
my-
Ram Soikia, there might be 7 Ram Soikyas.
And kindly, my lord, since the
Next.
2, 3, and 4 are the legal years of respondent number 1, they may be directed to but the names of the
You say next time when the matter comes.
Hello.
You say that it is not required, taking into account that the estate is duly represented.
Hello.
You want to make that submission today?
Yes. Yes.
Would you like to make it?
no, my
Don't make it then go. Next.
For official dated 25 code in IS 866, service is complete, my lord. 866, my lord, for setting as an abatement in constitution of the legal years of respondent number 5.
Who is Q Losco? Where is he?
For other respondents, but and because
None appears on behalf of the respondent on call. For the end of justice matters stand adjourned to be listed again after listed on 27th of May 2024. So it is made clear that if the respondents are not represented on the next day, this court shall pass appropriate orders in the
Right.
Yes, what is this?
It has already applied as the court for that type of time 31 I was there for the of so for that was also for step 1 I description of IA, description of AP, and authorization above for restoration. That case notice was issued by Learned Friend is appearing for 1 E D E F E I, but H S J Lordship Davidson. In IA 233. That sought for some time for filing objection, but it did not.
The appellant, the applicant is directed to take fresh steps upon the respondent number 1H and 1J to register post as well as usual within 7 days. List the matter of the completion of service. Applies to 233. Is it 233 or 295?
233.
230. Huh? I think it-
Okay.
None appears on behalf of the appellant on call. It further appears that no steps have been taken by the appellant. None appears on behalf of the petitioner on call. It further appears that on various that the appellants were directed to take steps upon the respondent. However, no steps have been taken. It appears that the appellant, the petitioner have lost interest in the instant proceeding, for which the instant proceeding stands dismissed for non-petition.
Okay, please, Your Lord. My lord, both the parties to this appeal have come to a compromise outside the court and according by executing a agreement. And in pursuance of that, a deed of exchange was executed also. Accordingly, I have, both the parties have filed.
But I have got instruction, they have compromised the matter. They have compromised.
This IA 1591,
Yes, sir.
I have not received that copy from my friend.
you on the last occasion on 7/8/2023, you appeared.
Yes.
You are Mr. K.M. Haloi.
Madam.
Then till date you have not received the copy. You
Correct.
said appearing however is not aware of anyone. He submits that though he has appeared in all the respondents they have not been filed by him. Now how is a compromise application being filed?
Then I
Only-
sent notice, my lord, and they have replied to me that they have entered in the compromise.
This is filed by whom?
Filed by both the parties.
How many parties are there? There is no signature of all the parties.
Yes, sir. From the appearance side,
Mr.
there are
Counsel? How is it possible to allow it? You are having how many? RSA means there are 8 appellants.
yes, sir.
If 8 appellants are there, where is the signing by 8 in the application? You want to withdraw the appeal, it's a different thing. I'm not, nothing to say. But if I have to draw up a compromise decree, isn't it that all the appellants needs to sign?
Yes, my lord, it is, but,
But it has not been signed. And there is also in the affidavit, it has been filed by one Mohammed Nasir Hussain Khan, aged 30 years, and Mohammed Didar Hussain. Who are those?
Gilded is one of the respondents.
one of the respondents and one of the appellants that
This can't happen like this. What will happen? I'll pass a decree out there tomorrow. They may say that we never filed out here. This is not how you do it. You want to withdraw the suit, sue. Appeal, withdraw it in view of the compromise. I can record that. But I can't make this compromise a decree of the
my lord, the time may be granted.
Learned Council appearing on behalf of the applicant in IAC 1591 oblique 2022 submits that some time may be granted to file a proper application seeking a compromise decree from this court wherein all the person duly signs on the application. Taking into account the above 4 week time is not much. All the persons, including that is the appellants and the respondents. Huh? Yes, what is this?
My lord, pursuant to the order dated 5/4/2024, I
Hmm.
filed an affidavit indicating that,
This is for what? For withdrawing.
yes, but no, my lord, this is for data condemnation and I have notified them. And on 5th of April, your lordship is directed me to file an affidavit regards the withdrawal.
Pursuant to the order dated 5/4/2024, the counsel who was earlier representing the applicants had filed an affidavit on 23/4/2024 stating inter alia, wherein it has been duly mentioned that the counsel have been trying to contact the applicants, but they are not responding. Under such circumstances, a notice of withdrawal have also been issued to him, which have been enclosed as Annexure X to the said affidavit. In addition to that, it is seen that the said notice of withdrawal have been duly received by the applicants on 25/9/2023, as would be seen from the track consignment enclosed, which is a part of Annexure X. Accordingly, this court accepts the withdrawal of the counsel, Mr. Adhor, from the instant matter and directs the registry to strike off his name and his associates who signed their wakalatnama on 21st of October 2020. This court, for the end of justice, adjourns the matter to be listed again on 19th of June 2024. It is made clear that if the appellants are not represented on the next day, the instant application shall be dismissed for non-application.
Apply.
এইটো সেইখিনি ওপৰখিনি হৈ গ'ল না নেম This court adjourns the matter to be listed again on 19/6/2024. It is made clear that if the applicants are not represented on the next, it
is not registered.
not registered, na, it will be in the step delay continuity. Itu is in I.
I.
That is 1591 is different. That is your application.
Okay.
That application is disposed. Right. No, ikon no. No. Aru kia. Okay kia. Na itu ikke order. Ikke order. How many applications are there?
But the main application 4311 is the for delay continuation in preparing the second appeal. Thereafter, during the pendency of that delay continuation, the respondent number 2 has expired. And we filed another 3 applications were filed for setting aside abatement, delay continuation, and for substitution.
Okay, first you put it out there in the stay application. And then not the delay continuation application. A order to. I could dispose one. That will be there. And when you are mentioning the 5/4/2024 in IA number 3072/2020, it will give first line to listen. In the order dated 5/4 this court had directed. Listen in so and all a good
It was passed earlier in all the applications. All the apply.
Yes, what are these?
But if the second appeal was filed along with delay condonation,
Ah.
that delay condonation petition was not submitted.
Ah.
Accordingly, we have filed a reparation petition along with delay condonation.
Then service.
Notice has not been issued.
Okay, you should notice. Econote IA 50. It will be an IA 50.
Well, IA 170.
What is IA 170?
That is a delay.
What is this?
It's a restoration.
IA 50 is for what? IA 50 is for restoration.
Yes.
Then why 1703 is what?
That is a delay.
It is for what? Delay for
49 days
in
filing the
restoration application. Huh? It you cannot notice in both. You should notice returnable 60. Except by register as well as in fact. What is this?
I'm appearing on behalf of Mr. Third Patrick.
Ah.
Mr. Third was no more in its access. I think it is directed.
Don't say like this. You have to file an affidavit. You can't say once you have done it.
Matter, my lord, I have been
It has already been admitted.
regarding service, my lord. I am
Ah.
the sole respondent, my lord.
Service is complete.
Complete, my lord. I have been instructed by the lord, I may be granted time for filing the power, my lord. I have been instructed, my lord.
Okay. Mr. M. J. Kadir appears on behalf of the sole respondent. None appears on behalf of the appellant on cause. Is the appellant representing or not? You are representing the appellant?
Yes, my lord. My lord, all services are completed, my lord.
Service, you are appearing for the appellant?
Yes, my lord.
What's your name?
R.I. Bhuya, my lord. R.I. Bhuya.
R.R.
R.I. Bhuya.
R.I. Bhuya
Yes.
appears on behalf of the appellant and Mr. M.J. Kadir appears on behalf of the respondent. Service is complete. LCR, LCR have been received. Accordingly, list the matter for hearing in future courts.
My lord, in a similar matter, my lord, the 2 years was filed, my lord. My lord, I may be allowed for filing an application, my lord, for early hearing, my lord.
Liberty, however, is given to the parties to file applications for early hearing.
Obliged.
Okay, 59 57 लगे हैं बाकी की तो हुई Any urgent matters anybody has? I would not like to see it. I have some other matters. Any urgent matters?
Item number 30.
30.
Yeah.
What is that?
Lordship, on the earlier occasion,
Ah.
the stay was not extended on the ground that no affidavit is filed on my part.
You filed it.
Filed it.
Okay, we'll take it up at 2. And anything else?
Item number 34, Lordship.
Yes, what is that?
Lordship, today we are appearing first date today we are appearing, Lordship. The stay order is operating against us, Lordship. Only 2 lakhs of rupees was given by the trial court. That was stayed by this honorable court. So we have
Okay,
some urgency.
34. I'll take it up at 2. Anything
Take your
else?
bit.
Other matters stands adjourned, huh? I'll take 30 and 34. You have?
31, Lordship.
What is that?
It's the CRP IO. We want
Okay, 31 I'll
Educate
take it. Anything else? Only these 3. Others may go, huh? Okay. Okay, let me take up item number 30. Yes, come. Just finishing in 10 minutes.
Yeah, Lordship, while order dated 3/4, they was not extended on the ground that I have not filed any affidavit as per the earlier order that.
As regard the stay,
Yes, Lordship, and further direct.
you are appearing for
Yes,
some?
appearing. And I have filed an IL, so I can number 40.
Okay. I attend it.
40, item number 40. something.
I for extension.
Extension.
What is this order case for?
It's a implement application has been rejected. So
What
for
application?
not
Amendment.
Amendment.
Okay, why?
Amendment part, factual amendment part is allowed.
Ah.
And there is a prayer to include Titul H Island in the prayer number 1 and A and B.
Okay.
That was it.
But I cannot. This is an application filed by the petitioner seeking extension of the order dated 27/9/2023. The respondent herein, the sole respondent.
Correct.
You are appearing for both. The respondents herein are duly represented by
P. Bharadwaj.
Mr. P. Bharadwaj. For the end of justice, the instant application stands allowed, thereby extending the order, the interim order dated 27/9/2023. That is the stay, the
Of the order.
27/9/2023 till the next date fixed, that is on 25/2024. Okay, 22nd of 22/5/2024.
Okay.
এইটো হ'ব I stands disposed. এখনত লিখিব list the instant matter heard Mr. S. Teka, the learned counsel appearing on behalf of the petitioner, and Mr. P. Bharadwaj appearing on behalf of the respondents. The interim order so passed on 27/9/2023 stands extended till 22/5/2024. Lists on 22/5/2000.
Okay.
Yes, what is this? What is the status of title to D?
It is pending, Lord. It is pending. It is awaited for the High Court order, Lord.
No. Why I say that there must be some reason. This matter should have come up for motion. No,
We have
notice has
taken
been
steps.
issued. Okay. Yeah, 21P. Now, what has happened? Is it
The-
pending?
Yes, sir.
How do you know?
I have inquired the engaged counsel. That's the
No, no,
matter.
where's the order? Last order.
Last order I have
Huh?
informed by a phone that the matter is
Let me have it again. I give you so much of time, then also nothing. List the matter again on 25/2024, on which date the learned counsel appearing on behalf of the petitioner shall produce a certified copy as regards the status of the list the matter again on 22/5/2024. The registry is directed to obtain a status as regards Title 2D number 91/2022, which was pending, which had been stated to be pending before the learned district judge Bongaigaon on the next. Report. Yes, what is this?
Lordship, in this case, Lordship, it's not available. So it.
Who is your senior?
AM Borguya and he expect to better maybe come next week.
Why? What is your problem, madam?
Lordship, problem is that the petitioner is staying with her parents, Lordship. Since July 2021, single penny was never given to her Lordship. And
Madam,
this
why don't you file an I?
Lordship for
You
vacating.
file an I,
Lordship,
we'll
because
take
2
it up.
lakhs of rupees only, Lordship.
Whatever maybe, we'll vacate it.
Lordship,
Let us vacate
that I
that
will
order
do, Lordship.
without a
26 years old lady, Lordship, she has to stay her entire life for only 2 lakhs of rupees. That has already been stayed by this honorable court. It is difficult for her to survive. I will.
It has not been extended. It is only till today.
Yes, Lord.
The
That
interim
is
order.
not been extended
Now,
because
if
it
she
is,
asks for extension, then you have an
Lordship, I have opposition.
objection.
Objection.
You want an adjournment? We adjourn it. We are not extending that order.
City order.
Absolutely. It is only till today. I can't help you.
Okay, Lordship, Monday. Monday.
I'm not extending it. Okay. At the request of the learned counsel appearing on behalf of the appellant, matters stands adjourned to be listed again on. What is that stay obtained from? There was a decree for divorce.
For divorce, awarding 2 lakhs of rupees, only 2 lakhs of rupees to the respondent wife. I mean,
So the divorce has been stayed.
stayed, Lord.
So, no, but anyway, don't you think Section 15 of the Hindu Marriage Act categorically say
Lord.
15 of the that Section 12 that when a marriage is being stayed, an appeal is being filed, automatically
This
amount
stay-
to stay.
stay-
Then
stay
how
must-
do you? I think you need to file.
Lord, I will file. But the position I am stating, Lordship. Only
Understood,
to
but
say-
how do I vacate it?
Lordship.
Because isn't that the mandate, the statutory
That
mandate?
it is there, Lordship. Statutory appeal.
Okay, Ms. So-and-so appearing on behalf of
Sole responsibility.
sole respondent submits that he requires 2 weeks time for filing a appropriate application, taking into account that the amount which was directed to be paid by the learned trial court have not been paid to the
Petition, for the respondent wife.
liberty is given to her to file such an application which shall be duly considered on its own merits. List the appeal along with the interlocutory application on 2 weeks time na appeal na. Today is on 25/2024. The interim order passed in IA Civil 437/2024 stands extended till then. Anything else? No?